Mr. Wilson joins us. Mr. Wilson, good morning.
Morning.
So I have read your motion, Ms. Borsch. I have also read the response. Um, is there anything you'd like to add before I hear from Ms. Wilson? And I do have a couple of questions, so I'll give the floor to you first.
Sure. So to summarize, as you're aware, we're looking to clarify the Labor Day, Memorial Day, the exchanges, who, when, where, and the Christmas break and the inherent rights. The parties tried to get this resolved via mediation with the friend of the court, not successful. I sent a proposed offer that was not accepted. We filed the motion, and then belatedly, Ms. Wilson signed a signature page and sent it back. I realized in looking at that, Your Honor, that we didn't address the Christmas break in that first draft, which is important for the parties to divide. So I thought we would go forward with the motion because it had been filed because I hadn't heard from her. Mr. Wilson has missed 2 days of parenting time, and I was very surprised, as was the friend of the court worker who mediated for them, that the friend of the court didn't enforce. The order doesn't say that third parties can pick up, but I've never in all the years I've been practicing had someone deny time to the other parent because it wasn't that person. Frequently, life happens. We have nannies, we have grandparents, we have other people picking up the children, but the friend of the court refused to enforce his time because it didn't specifically say in the order that we needed a third party provision to be able to pick up. And last, Your Honor, we're asking for attorney fees and costs, and I set forward my affidavit and my time spent on this matter.
Thank you. I have a couple of questions for you, Ms. Pagorsh, and then I'll hear from Ms. Wilson.
Sure.
So, how often does your client travel out of town, whereas this is a issue, his mother being there to receive the children? How often does that happen?
I don't know the answer to that, Your Honor, but I do know that she is his childcare provider during the work week. So she cares for the children a lot when he's working. As far as the travel out of town, I don't know how often that's happening. I do know that Ms. Wilson has requested a right of first refusal, and I think that that would be problematic for this family, as it is for many families.
Um,
I can tell, Your Honor, to excuse my interruption, but I can tell you that if you ask Mr. Wilson, do the boys have a good relationship with grandma? He would say yes. It's concerning that Ms. Wilson is telling the boys, ages 5, they're twins, that dad is a bad man. She doesn't like dad. She doesn't like mom, or excuse me, grandma, and she's not going to lie to the boys. They're 5, Your Honor.
yeah, I've read all that. And you are aware, are you not, at least from my reading of Ms. Wilson's response, that she is in agreement with the inclusion of a provision relative to Labor Day and Memorial Day, but it appears the only difference between that is that you are requesting that that take place on the Friday preceding the holiday at 8 a.m. And it looks like her request is to begin that the Friday after work or somewhere around that time. So you're getting closer on the Memorial Day and Labor Day issue. Were you aware of that, Ms. Pagorsh?
Yeah, I'm aware that she was willing to agree to the preceding weekend for both the Labor Day and the Memorial Day. I also understand that when she signed the draft that was sent to her before we even filed the motion, that included the additional language with the inherent rights provision. And it also, well, what it didn't include is the specificity with the division of the Christmas break. It did have the to school or, allowing for third parties and whatnot. So candidly, I think where we're stuck, Your Honor, is the Christmas break and her request for right of first refusal.
Well, and that brings another point to mind. I was not aware from your motion that the Christmas holiday was even at issue, because it's not, um, at least it wasn't to the specificity of the Labor Day weekend. What are you proposing happens during the Christmas holiday?
That they equally divide the break. The way the parties have divided the Christmas Eve and day, that goes to plaintiff each year. And then Yule, which they've defined as December 21, goes to Miss Wilson each year. So I kept those in with the parties dividing the break depending on when the break is, if it starts before Yule or if it starts after or at the time.
Okay, and your proposal is what? They divide that?
Yeah, that it's equally divided, the Christmas break.
Okay. Ms. Wilson, I read your response. Thank you for that. Um, I have a couple of questions, and then I will certainly give you the floor with whatever you need to tell me. Um, what is the name of the mental health provider who has opined on the discussions you have with the children about their father?
It's Laura Hockenberry.
Okay. Could you spell that last name, please?
Hockenberry.
Okay. And the only reason I'm doing that is because at some point, quite possibly, she may be subpoenaed as a witness in this case. But that was my first question. My second question is, there seems to be a problem, at least from your perspective, as to the paternal grandmother. And it was somewhat of a disturbing picture you painted with a couple of little kids cowering in the back seat of your car. What is your, I guess, issue with Mr. Wilson's mother?
I've had concerns with her as a caregiver for them based on the incident that we had when they were, I believe, 1.5. Before that, I didn't have an issue. What happened was my son, KW, had been having some irritation with his diaper changes. And so she had been going to change his diaper. And I said, oh my gosh, let's double check that, make sure he's good. His butt's been getting red. And then within the next week or two, I noticed that she would kind of casually mention she thought that they needed a diaper change. She had been in the household helping, so I wasn't paying full attention to them. And I eventually did ask Mr. Wilson. I said, I think she's not changing their diapers. I don't know what's going on, but I'm getting the sense of. So it was a few weeks. And she actually, both of them said, yeah, she decided that she wasn't going to do that. And to me, that gives me concern for all the other decisions you're making. When we went through the divorce, I was told that that was not enough to object officially to it. And so they've been going to her. But when it was only AW who hid in the car, that immediately threw all my concerns back up.
How often, from your perspective, does Mr. Wilson travel, and what is the purpose of that travel?
So I would say it's probably 4 or 5 times a year so far. I believe in the past year, 3 of those times were to visit a significant other, and I think the 2 others were for work.
Okay. And how long is he usually gone for?
In total, or that he's not with his parenting time?
Yeah, I mean, if he's out of town for, let's say, work or whatever, I mean, is he gone for a week, 5 days, 3 days, 1 day? What's your understanding of that?
So far it's been between 3-ish days and a week.
And then his mother would in essence be the caregiver
Correct.
at that. Okay.
Correct.
What else you want to tell me?
The concern with the winter holiday, I have 2 concerns to that. The first one is that I know this is a difficult one because Yule's not on everybody's schedule, but it typically for our household runs just like a Christmas would. So we do kind of Yule Eve, if you will. And that it was written in the judgment of divorce. So it started on the 20th instead of the 21st. And the way that they've proposed it, it starts that morning. We do, wake up and Santa brought presents. So that doesn't work if we start at 8 a.m. in the morning.
So you would like that to start noon?
The 20th. The 20th, just it would mirror the Christmas holiday for him. So it would be the same hours as his, only it's the 20th and 21st instead of the 24th and the 25th.
Okay.
And then the second part of that is with their proposal, I'm great with splitting the winter holiday evenly. The problem is they have it contiguously, and I can't always get my work to be a straight chunk of time off. In the past, what we've done with the holidays is just said like, oh, you're only going to get 1 day and then it's back to a chunk, and then 2 days. We've just sorted it out so that it could flow evenly, which I'm okay with, but I'm leery of writing it down specifically like that and then having it not financially. That would be difficult for me if I have to take a whole bunch of days off. And I'm a florist, so that's one of our busier holidays.
Stands to reason. So your, I guess, solution to the Christmas break is to just leave it as it's set in the judgment?
Yes. I mean, if there's some way we can specify, I don't mind it saying split them evenly. Just that contiguous chunk could be a problem for me.
Anything else you want to tell me?
Let me just check and see if there's anything else. Oh, I would like to say that I did offer him makeup parenting time when we ran into that snafu with the kids. So I'm fully aware that I want him to have all of his time. It actually hasn't been requested. So I'm not sure where that stands, but.
You mean it hasn't been requested from you? It's apparently been requested from
Yes. Yeah.
the folks at the front of the court.
Yes.
Ms. Pagorsh, I'll give you the last word.
Thank you, Your Honor. Mr. Wilson has texted me during the last 2 years. He's traveled 3 times personally and 2 times for work. And as far as the break for Christmas, as Ms. Wilson's indicated, Mr. Wilson's significant other lives out of state. So he would like the opportunity to have a block of time over the holiday to be able to travel with the boys to see her, or to have her come and stay with him and the boys. That's important to him. So an every other day kind of schedule would just be problematic. And that's what we're trying to avoid over the break.
Well, let me bite this off in smaller chunks for everybody. I, I think the parties who are arguably very good parents, that they're ratcheting up this parenting time so much that there's not going to be any flexibility from anybody. It's too rigid, in my view. But that's up to the parties. Usually, I don't get a motion to clarify a judgment that was prepared by probably two of the finer attorneys in Grand Rapids. Usually they clarify it for me. I rely on them to clarify things quite a bit. But let me see if I can take this in bits and pieces. I'm going to start with the Labor Day and Memorial Day. There's no dispute that it's going to start on that Friday before. The dispute is what time. And Mr. Wilson would like 8 a.m. Ms. Wilson would like after work. And I'm going to order that it be after school. So when the children are done with school. In the same manner, because the parties have their own way of doing things as far as pickup and drop off. Same manner. I mean, the easiest way to do pickup and drop off, but the parties haven't done that here, is to just, if you begin parenting time, you usually pick up the children, and at the end of it, the other party does. But parties have somewhat kind of amended that a little bit, and I really don't have a problem with the way they amended that. Let me speak a little bit about inherent rights. MCL 722.24 charges courts with, in all actions involving the dispute of minor children's custody, the court shall declare the child's, or children in this case, inherent rights, and establish the rights and duties as to the child's custody, support, and parenting time in accordance with this act. I don't know what the credentials of this professional are, and that's somewhat why I wanted to know who it was, because if that ever comes down the line, then Ms. Gorsh can do a deeper dive on this individual. But my my policy when it comes to inherent rights of the minor children is that if you don't have anything nice to say about somebody, don't say anything at all. I mean, we were taught that all as what? Kids. And that's somewhat how I operate here. See, I want these children to think of their mother as a rock star, a greatest mother in the world. And I want them to think of their father that way too. And I can't have people saying things that are going to possibly jeopardize that, even though the professionals may weigh in with some other thought process. But I am of the opinion that people should not involve their children in that type of activity or those types of statements. It's very easy just to hold your tongue, hold both of your tongues until a time is when there's nobody, when the kids aren't there. So that's the way I operate with that. So I don't have a problem with the inclusion that Ms. Pogorsh put in her exhibit. I think it's exhibit 4, with that language. As far as the right of first refusal, I don't have those because they are ultimately problematic. They I've seen some that if you can't be with the children for 6 hours, then it kicks in. 3 days it kicks in. 10 days, 1 week. My preference is to tell the parties that obviously, if a party is going to be out of town and not able to exercise any time, the more prudent thing to do is maybe tell the other party that and say, hey, can we switch some days on and off? That's usually how it works. And that's how I think it should work in this case. So I'm not going to order a right of first refusal yet. But and it doesn't sound like this is a huge issue with that. If there's a problem with Mr. Wilson's mother and these children, then I think everybody should be involved in that discussion, because I don't want children to be nervous, stressed, scared, all that stuff when it comes to their paternal grandparents. The one, in as far as splitting the winter break, I want to split it equally. And if this becomes a problem, Ms. Wilson, that these chunks of time are not easy to get off from your employer, then you can bring that issue back to me and I'll do something else with it. But I think for now, I want to start with Ms. Pogorsh's equal during that time. I'm a little confused about the uniform child support order, because it seemed to me anyway that the friend of the court did, or the attorneys did, a dive into that, and then agreed that it would be a higher amount, and they deviated. And from what I read in your submissions, Ms. Wilson, you no longer want that. You want it to be what the friend of the court ordered originally, or am I reading that wrong?
Well, it wasn't written in, and he had been actually paying it, but it was causing stress to the situation because I would have to remind, etc. I'd prefer just to go through the friend of the court, and then there's no interaction about it. We don't have to talk about it. It can just be what is ordered from the friend of the court.
So, Ms. Pogorsh, I guess you're going to go back to the UCSO that's in the file dated March 14 of 2023, right?
That sounds like it, Your Honor.
Okay.
Your Honor, I did have one question. Sometimes I know that schools are starting earlier and then they have like days off around the Labor Day holiday. So if the Friday before Labor Day weekend is not a school day, what time do you want the parties to start?
I even checked that, Ms. Pogorsh, because I anticipated that question, and it appears anyway that the children would be in school on that
Okay.
Friday. Now, obviously, the parties are free to start it if they're not in school. One wants to start it at 8 in the morning. One wants to start it at after they get out of work. So if there's no school that day, make it noon
Okay, thank you.
I am going to respectfully deny the request for attorney's fees. I thought long and hard about this. In essence, this, I believe, anyway, this is a problem of the party's own making, both parties. And I would hope that in the future, the parties understand that I am a firm believer in agreements between the parties and not coming to court. So I hope that that gives you some philosophy on what goes on. But if I find that people are being obstreperous, not doing what they're supposed to be doing, and causing this file to escalate, I won't hesitate. Can you prep that order, Ms. Pogorsh, please?
I will, Your Honor, and may I also add that Mr. Wilson is entitled to the 2 makeup days, as Ms. Wilson has acknowledged.
To be determined by the parties. I'm not going to weigh in on when those are going to be.
I did have a question before we go.
Okay.
The question about the right of first refusal, I had written in there, I was hoping for it to be ordered just when someone is out of town, so that it wouldn't be, you know, whenever, to be very specific, because neither one of us are out of town very often. It could clarify it.
Yeah, I read that. I understood exactly where you're coming from that. I don't like rights of first refusal. I don't, they're very difficult to enforce, and quite frankly, it throws off the balance of what you two seem to have tried to do, and that's to make an equal allocation of the parenting time. However, as I said, if I find out that these out of town travels are going longer and are more frequent, you can knock on my door again, and I will consider it when that issue comes up. But I think I worry that these children are so young, and that everybody is kind of, you need to build in some time here for things that happen, because once your children start participating in sports, extracurricular activities, band, drama, all that kind of stuff, the parents have to be able to work around those things. And it's very difficult to do that when parents specify every hour of every day of where the children are. So I hope they take that into account. Ms. Pogorsh is going to prepare the order and send it to you, Ms. Wilson, for your signature. 7-day rule, Ms. Pogorsh, is that how you would prefer it, or?
Your Honor, I will try and work with Ms. Wilson. If we can't get it figured out, I'll send it under the 7-day.
Okay, very good.
Can I clarify that? Are we writing anything in there that we are going to offer the time if we're going to be out of town to the other parent?
No, that's just what I suggest the parties do.
Okay.
I'm not going to make that part of an order. I think the parties should do that. It makes more sense. But I will leave that up to the parties' capable hands. It's a pleasure meeting both of you. I've read a lot, because everybody is pretty prolific in their submissions. But it's nice meeting both of you. I hope, don't take this the wrong way, I hope we don't bump into one another on a Friday morning again. Thank you both very much. Ms. Pogorsh, always a pleasure. We're adjourned. Thank you.
Thank you, Your Honor, for your time.
Good morning.
I've read your motion. Did you get a copy of that, Mr. Seitzma?
I did.
Okay. Ms. Kreima, is there anything you'd like to add to it before we hear from Mr. Seitzma?
I do not believe so.
Okay, Mr. Seitzman, I'll give you the floor.
All right, so I do agree with the law, that my son, our son, is able to, for post majority support. I guess my biggest thing is based on our last support order, we did not check the box for support, post majority support order to go on until after 18, which I don't know if that is significant or not. And then also, being so, I feel like the other party should have had the responsibility to notify FOC prior to my case ending, to keep the support going. And then what else? And then with that being said, I know my son our son, sorry, has only 2 trimesters of school left, and I think based on the law, he has to be a full-time student until he graduates. Which I don't know if he meets his certain credits, because he ends at his second trimester, which I think would be like January or February, and then he's done with school until graduation. And then also I know, my son has a job, or our son, sorry, and pays his own bills and everything else with that. So I just not really sure on how all that goes well.
Okay. Ms. Kramer, anything you want to add?
Yes, that is somewhat true about the only 2 trimesters at school. However, he will be in either a work release program or he will be in a program released from his VOTEC, which is an educational center that he goes to. None of which is finalized until I believe it's October 7th or 8th. I have an IEP meeting with the school and they will confirm at that time if Logan is completely eligible for the work release program or the VOTEC release program. He will still be enrolled in school. He's not like graduating early. He's not leaving school. And I don't know if he will still be required to have some time in the school building that 3rd trimester, or if he will be kind of on his own. As far as my son paying for his bills, as Nick has stated, my son is a very responsible child, young adult at this point. He does work very hard. He does put a lot of hours in during the summer, ranging to 50 to 60 hours. He does work every day after school. However, the only bill that my son pays is $50 a month for his car insurance, and he's responsible for paying his gas. I cover everything else when it comes to him, his phone, his health bills, dental bills. I clothe the kid, also using money that Nick has gave me for child support. But that's not entirely true when he has stated that he pays for everything. And I do not believe in my heart that a child who worked so hard to make a living for himself, to have a bright future, should have child support taken away his senior year when he's still responsible for being at school.
Well, I think you both somewhat hit on the point here. He's not a child, he's a man. He's an adult, he's 18. Michigan compiled law 552.605B as in boy provides that a court may order post-majority child support if the child is residing on a full-time basis with the recipient of child support, that being Ms. Kramer, and I have not heard anything to the effect that he is not. while attending high school. Question is it or is it not on a full-time basis? Well, I rely on the school because in order for them to receive the funding from the state of Michigan, they have to be a full-time student. And if there's any question of that, then the school would write a letter on his behalf and go, yes, he's considered a full-time student for that purpose as well. As far as the last part, reasonable expectation of completing sufficient credits to graduate. Yeah, it sounds like he's on his way to do that. I cannot order anything past 19 and a half. That's where it stops. But everything as far as this goes, as far as the box being checked, certainly would have made things easier. I don't know who prepared the uniform child support order that governed everybody, but it certainly would have been easier if that box would have been checked, because it would have also required a date, and then it could have been somewhat seamless. So I'll make their very valid points, Mr. Seitzma. What I'm going to do is I am going to grant the motion for post-majority child support. I'd like you, Ms. Kramer, I know you attached something, but all I have is a copy. I'd like you to submit another uniform child support order and send a copy to Mr. Seitzma, providing for what I just ordered at this point. And it should be seamless, meaning when they stop the child support, it should pick it up right from that date. Okay, so if they stopped it 2 months ago, it should go back 2 months because it's supposed to be seamless. Does that make sense to you, Ms. Kramer?
Yes, the seamless part does, but where do I go, or how do I send an informed order of child support? How does that work?
You would have to go to, you live here in town?
I live in Door, so I'm technically
Okay.
Allegan County, but yes, I'm
All right.
easily accessible to the courthouse.
Straight shot down 131.
Yep.
You got to go to the Legal Assistance Center on the 5th floor. And
Yep,
they
and that's where I went to start this motion.
exactly, and they will show you where to finish this motion and what you need to do. I need a
Okay.
uniform child support order reflecting what I ordered today, with a copy to Mr. Seitzma, and then I can sign that, and it should be, the commence date should be the date your other one terminated. That way there's no gap in the child support. Okay, so you can get that prepared, and they will show you how to get that to me and get a copy to Mr. Seitzma, and and hopefully he'll have a stress-free senior year, and you're all set with me both. Thank you both very much. Nice to meet you both, and
right.
We're adjourned.
Thank you for your time today. Have a blessed day.
Have a good one.
You too. Thank you. So I have read the motion. Ms. Williams, did you get a copy of that, Mr. Schaefer?
Yes.
And I've read your response as well. And did you get a copy of that, Ms. Williams?
Yes.
All right. I read it both. I understand it. Anything you want to add today, Ms. Williams, that I don't already know by your motion? And then we'll hear from Mr. Schaefer.
Yes, I'm really just asking to split the summer, no change in really the holidays or anything. And he can also have spring break if needed be. Also, I want to put out that he hasn't been following the school year that he's supposed to come every other month. He only came one time, which was last year, September 2024, and he did not follow the whole thing, which is staying for the whole weekend. He took him to a basketball game with a whole bunch of his friends and brought him back that same day. Other than that, he hasn't followed the school year parenting order.
Okay, so what do you suggest I do about that? Are
I
you
just want,
asking, hang
go
on, a
ahead.
second. Let me get the question out first. Are you asking then that I eliminate his parenting time during that time frame, or what are you asking this court to do when Mr. Webley has not abided by the parenting time order relative to in-school parenting time?
He should be held accountable, because for instance, before we had a motion to ask to split the summer, that was already asked, he disagreed. He goes so hard about having his summertime with him, which I don't have any summertime with him, or I don't have freelance throughout the school year because I'm busy, I have to work, I'm in college, my son's in school too, so like I'm strictly business throughout the school year. So I don't have time to travel with him or do major fun things or travel out of town with him. I think he should be held accountable because
Yeah,
he
but
doesn't have,
that's my question.
I
Whenever
didn't get to finish though.
hang on a second. Whenever you propose a problem, you have to propose a consequence. So what is the consequence you're asking me to do for him not abiding by the in-school parenting time? That's what I
Well,
want.
what is the consequence when you don't follow a parenting order?
Are you asking me questions now?
I'm asking you, yes, because
No, you don't get to ask me questions. I get to ask you questions, so that's kind of unfair, but
well, I'm not here to take away any of his parenting time. I just feel like he should be held accountable. I'm not here to
right.
take away any of his parenting time. So
And
whatever happens when you file a complaint and the other parent doesn't follow the parenting order, that should be the consequence.
okay.
It's not for me to,
Did you say it's not for you to decide
that's
that?
not for me to decide his parenting time. I feel like
Okay.
he should follow it, of course, but that's not for me to take away any time with his child.
Okay. Mr. Schaefer.
I'm hearing contradictory things. Ms. Williams says she doesn't want to take away his parenting time, and yet that's exactly what her motion proposes. Now, we did indicate that she gets 3 weeks with the minor child in the summer, and 2 of those weeks are in August, so they have time for a long, leisurely vacation. It was not clear to Mr. Webley how much of an issue the 1, 2, 3, 4, 5 weekends during the school year were to Ms. Williams. He had been exercising the parenting time every 90 days instead of every 60 days, and will scrupulously adhere to the order going forward and do the weekends every 60 days. There have been issues with Ms. Williams in terms of she has serious anxiety and
No, I do not. That's not court.
Oh,
You do not have my medical history to say that.
Stop a second. Ms. Williams, I know you're representing yourself, but you do not or cannot just jump in whenever you feel like it. It's your motion. I will always give you the last word, but you can't interrupt people because not only is it rude, but it mutes out microphones and then I can't hear what's going on. So,
I'm sorry, Your Honor.
Mr. Schaefer, sorry about that. Go ahead.
So Ms. Williams has made it challenging to exercise the parenting time, but we're going to persevere here and make it happen this school year, Your Honor. And so that's something Mr. Webley is perfectly capable of and willing to do. This just came up really in the spring. It was sent to mediation with the Dispute Resolution Center. Ms. Williams elected to go with friend of the court, and it wasn't worked out. So now that we're here with the school year, we can scrupulously adhere to the school year parenting time.
I give you the last word, Ms. Williams.
That is not, you don't have no say so of saying anybody has anxiety or anything of that case, honestly. I don't get, we had this since 2022. To only come one time out of all of those years, that makes no sense at all. Like, what makes, now that I file a motion, that you're gonna step up and do what you're supposed to do? That makes no sense to me. And if he followed the school year of coming to see him like he's supposed to, it wouldn't be such an argument of him wanting to hold the summer hostage, because those 3 weeks that he comes back, yes, I have to get him back on track of, hey, back on bedtime, because his bedtime during the summer is 11 o'clock. I have to go to the dentist, his doctors, and get him back trained to get ready to get up at 7 o'clock in the morning and go to bed at like 9. So those 3 weeks are not enough time for me to do what he says that I can do, is travel for a long time out of state. That's not what I do, because guess what? I'm in college too. School starts for me around the same time as our son does in August.
Thank you. Well, I received a motion that in essence said that or asked that parenting time be changed. And courts cannot just change parenting time. There has to be something called a threshold that was set forth in probably the seminal case in parenting time of Shade versus Wright, 291 Michigan Appeal 17, a 2010 case. It says I have to have proper cause or change of circumstance, even if it's not as stringent as the custody threshold. What was alleged in the motion was that first, the defendant is inconsistent with school year parenting time. Second, that the child misses out on free opportunities for those types of extracurricular activities. And third is that the child is suffering from emotional stress. There's nothing by way of any type of medical professional that I read anywhere that backs that up. It may be that he is suffering with stress. Let me turn first of all to the school time, parenting time. Courts enforce court orders. And if Mr. Webley is not following the court order, as Ms. Williams suggests, during the school year, then pursuant to statute, MCL 552.644, she should file a complaint with the friend of the court. They will then try and resolve it between the parties. And if they can't, they will bring it in front of me on what's called an order to show cause. And then I'll have to determine the penalty for it. It'll be either a monetary penalty. If it's so egregious, I could quite simply discontinue the school year parenting time. And if it's really egregious, could recommend that Mr. Webley be incarcerated. Those are all things that are available when somebody doesn't follow a parenting time order. And I'm prepared to do any of those things, but those have to be initiated at the front of the court, not with me. So I will leave Ms. Williams to that if that situation arises. But at the end of the day, I do not find any proper cause or change of circumstance to change any parenting time at this stage. And I'm going to respectfully deny the motion. Mr. Schaefer, will you prepare that order, please?
Yes, I will, Your Honor.
All right. Thank you both, or all of you, very much. and I wish the best for all of you and your son. What can I do for you, Ms. Williams?
If I disagree, because I went to legal assistance, they tell me if I disagree with you, that what do I do after this? Because I 100% disagree. Just come back up there and file
You
another.
can 150% disagree with me. You always have the right, and wait till you get Mr. Schaefer's order. It'll say it right on the bottom of what you need to do and the time frame you need to do it at. You can try your motion with Judge Gottlieb. Okay?
Yes. Thank you.
All right. Thank you. Make sure the 21-day objection language is in there, Mr. Schaefer, please.
I understand, Your Honor. Thank you.
Thank you. We're adjourned.
And next, we're going to move to number 12. And that is case number 2502787 DP Walker versus Bass.
Good morning, Your Honor.
Mr. Gonzalez, good morning. Nice to see you. First on my screen is Keisha Walker. Ms. Walker, good morning to you.
Good morning.
And next on my screen, on behalf of the people of the state of Michigan, Assistant Kent County Prosecuting Attorney Caleb Gonzalez. Mr. Gonzalez, good morning to you.
Good morning, Your Honor.
And finally, on my screen is the defendant in this matter, Isaiah Bass Sr. Mr. Bass Sr., good morning.
How you doing?
Good. If you'll permit me, Mr. Gonzalez, for the record, a complaint for paternity was filed on March 26th of this year. It was served on the defendant. I believe it was April 15. The Register of Actions notes it as April 15, 2026, but it must that must be an error, and it must be 25. A default was entered against the defendant on June 11 of 2025, and a judgment of paternity was entered along with a corresponding uniform child support order dated June 26 of 2025. An order of affiliation was sent to the state of Michigan on August 5 of 2025, and that obviously settled the paternity issue between the parties. Mr. Gonzalez's office filed a motion for entry of an amended judgment of paternity and set that matter for today's date. And the support that is asked for is $0 because apparently the people discovered that Mr. Bass Sr. Is receiving income from a source that the child support guidelines will not allow be used in the calculation, that being SSI. There are no overnights still in this calculation, and the 4D birth expenses were waived. Any uninsured medical expenses are still covered at the 54% for plaintiff, 46% for defendant, and the actual income for plaintiff was used. But as I indicated, the support for, or the income for the defendant is not allowed to be calculated under the support guidelines. Mr. Gonzalez, anything you want to state for the record, and I will then hear from the parties.
Yes, Your Honor. I just want to add that this came to my attention that the client was receiving SSI, and I did confirm in an email with a friend of the court that he was receiving SSI, and that prompted this motion. You summed it up perfectly, so thank you, Your Honor.
Thank you. Ms. Walker, anything you want to add?
Just that he does get overnights with him.
Okay. And I take it you work those out yourselves between yourself and Mr. Bass?
We do.
Okay. And I don't think Mr. Gonzalez has any problem with that whatsoever. Mr. Bass, anything from your end?
No.
Okay. Well, I am going to sign the amended judgment of paternity. Once your wonderful staff sends that over to me, Mr. Gonzalez, I will sign same and get that back so the parties can start following that. Anything further, Mr. Gonzalez?
Your Honor, I just want to make sure to put on the record that any child support that was due or still pending, it will be waived.
So any arrears will be waived. Okay. You should probably put that in there somewhere. And everybody should pay particular attention to paragraph 13 of the Uniform Child Support Order, because that's the paragraph, if anything changes, that you got to let the FOC know what's going on, because they will not have, they would not know it otherwise. Okay.
Okay.
So you both are all set with me. Thank you very much. I wish you both the best of luck. And Mr. Gonzalez, great seeing you again. We're adjourned. Thank you.
Thank you.
Okay, thank you.
I'm gonna move to number 7 next. Case number 1806091 DM Jackson versus Jackson.
Well, I don't quite know what the parties do for a living, but they generate a mountain of paperwork, a mountain of it, this much. I really don't need all that. And let me just begin with, even though I read it, Ms. Hernandez Jackson, there is no such thing as a reply to a response. Okay, that's not at all called for in the court rules, and I have to strike it. I did read it, but it's not a proper document to file, because quite frankly, as you could guess, if they allow your reply to his response, then he's going to follow or file his reply to your response, and we're going to be at this thing forever. Plus, responses have to be filed at least 3 days before the hearing, and this one wasn't. But I did receive the original motion, and I did receive the response from Mr. Jackson. And before I turn to the parties, I'm going to tell you both this. You have a problem that has taken a long time to create. This child is 15, and when children reach a certain age, it's hard to force relationships upon people. Anytime there's a dispute between a child and a parent, the first line of defense for that parent is to blame it on the other parent and say they're alienating them. I don't know if that's going on or not. But I read some very disturbing things in here, things that don't quite make me happy. There have been numerous motions in 2022 on this case, and the last motion was October 25 of 2024. The last custody order was June 20th of 2019. And that was the judgment of divorce, and the parties were granted joint legal custody, with plaintiff awarded physical custody. And now we are here because we have problems with this 15-year-old daughter. So I read your motion, Ms. Jackson. Anything you want to add to it before we hear from Mr. Jackson?
Of course. Thank you, Referee Winter, and thank you for the feedback. I appreciate it. Um, I am here today as a mother who's deeply concerned about my teenage daughter. I do hear your concerns about relationships not being forced, but prior to the incident that happened August of 2024, my daughter and I did have a relationship, and I'm looking for reconciliation. My goal is peace, healing, and stability for her, for myself, and for her younger sister. And my concerns stem from violence that has been, as you see in the evidence provided, acted towards me. It's been towards the younger sister. And unfortunately, I had to make a really hard choice, Your Honor. A choice where if my eldest daughter's actions, how they would impact the youngest child, who I am solely responsible as her father, left the picture when she was 4 months old. So I am the sole provider in that situation. I want the court to know that I have not contested paying for my daughter's needs, our daughter's needs. I continue to pay child support. I cover the phone bill for Mr. Jackson's eldest daughter. I was married to him for a really long time, so I feel like it's the right thing to do. And she's had a lot of behavioral issues with Mr. Jackson in the house and just et cetera. She ended up having to go to military school. So that's the one thing I could commit to while I'm in an active Chapter 13 bankruptcy. And I even pay the YMCA membership for him and the children so that they have that. But despite paying Mr. Jackson, ultimately, he has placed limits, whether we get therapy. He has used the words against me. His sister has threatened to kill me. My youngest daughter came home in August of 2025. She saw her eldest sister and she told me, hey, Jayla hates you. Excuse me, I'm so sorry. JJ hates you. And mommy, her aunt wants to kill you. And JJ said she's going to take you away from me one day. I am just asking, Your Honor, for a guardian ad litem. I've sat with legal aid too over the past couple months to work on this because transparently, Your Honor, it took me a while. I do not live in Grand Rapids. I had to turn over my car because I'm in an active Chapter 13, and now I'm in process of getting a new vehicle. The trustee has approved it due to my youngest daughter being in a school district that requires me to have a vehicle. And I'm asking for friend of court review that includes therapy history, the domestic violence context, and academics, and to allow me to obtain the 5 years of records to provide that to the FOC review, order neutral court approved reunification therapy with no unilateral provider charges, and provide support such as high conflict parenting education through FOC resources, and enforce parenting time that is consistent with our original agreement, but after reunification therapy and things are safe for my youngest daughter and I, because that is my biggest concern. JJ has been violent towards me. JJ has been violent towards the youngest child. JJ has been, unfortunately, I believe, coached and trained to say the things that she said to her grandmother, who is 68 years old. JJ was telling my mother and my child that her aunt, Casey, threatened to kill me. And I am just extremely concerned. And I have tried my best, but also I was very sick. I had a emergency surgery in the middle of March that also delayed to this process. And I had a lot of complications with that surgery. I ended up losing an organ. So I just got off FMLA recently and I'm still, adjusting to like a new normal with a missing organ. So I'm just asking for the court's help. That's all I'm asking. My daughter and I talked actually yesterday because I told her I'm buying this car. Hey, this is something I want to give to you next year when you're able to drive yourself to school. She was like, I like it. It's great. But there are some deep-rooted issues that we need to talk through and address before I can have her in my house. I'm scared. And I know I've communicated with you back in the hearing in February. And I'm not just scared for me, I'm scared for my youngest child. When you have an eldest child.
Okay, I got it.
Yeah.
Hernandez Jackson, you're starting to repeat yourself.
Okay, sorry.
That's all right. We don't appear in court all the time. I read those things that you requested, and quite frankly, those are going to be cost prohibitive for you. A guardian ad litem costs $5,000 to start, and usually I will split that if I feel that both parents are not looking out for the best interests of their child. Right now, I don't have that yet, but it's a tool in my toolbox. Mr. Jackson, what's going on?
Yeah. Good morning, Your Honor. I'll say I take great offense to how the plaintiff is characterizing my relationship with our daughter and our daughter overall. She does deal with depression and anxiety. Yet my daughter has had lead roles and plays as a freshman last year. She's on the softball team. She carries a 3.0 grade point average, despite of the challenges that she's had with her mom. She has weekly therapy. We're up to date on all medical and everything. We're up to date to. The plaintiff has access to school records, medical records, everything. She's in the past set appointments, everything that she stated within her motion, she has access to. As far as any violence or whatever, I don't communicate with Miss Jackson unless it's about our daughter. We have not had interactions, personal interactions in years. These things that she's characterizing is false, really. The notion that our daughter told her daughter about my sister is just false. It's just false. And in the past and in my attachment, I've shown Miss Jackson has asked our daughter not to speak to her. She's asked her not to reach out to her family. She's told a 15-year-old, please don't contact me or my family. How do you do that to your daughter? That's an issue between Miss Jackson and our now 15-year-old daughter. In the past, I have tried to help heal this relationship. Within the past year, I've driven down to Detroit 2 times for our daughter to see her sister, who is not my child. That's not my child. But I want to foster a relationship between her and her sister. Me and Miss Jackson, after the October 25 hearing, had an agreement that we would meet monthly in Lansing. The first meeting Miss Jackson canceled because of transportation, and then got upset with me because I said I would not make a weekly trip to Ann Arbor to spend 8 hours stranded, basically, while her and our child spend time together. On top of it, I have to be around if it's just them because Miss Jackson, in the environment she's created, is hostile for our daughter. And I have to be around in case I need to come pick her up or grab her. Your Honor, honestly, this relationship has nothing to do with me. Our daughter is 15, intelligent, and bright, and has the tools to help start a healthy relationship. Miss Jackson should seek a relationship with our daughter. This has nothing to do with me.
Well, one of the things that concerned me was there was an allegation that you, even though both parties have legal custody, that you unilaterally placed the child in therapy, that there's been some medical neglect, that there was a drug overdose that she didn't find out about. Those are all legal custody issues that need to be discussed between you and Ms. Hernandez Jackson before you do those things. Do you both understand that?
Yes, Your Honor.
Your Honor, she had the opportunity to help with that. I used the app that she provided me to seek counsel for Miss Jackson, and then I provided her all the information once me and our daughter settled on a therapist.
Okay, here's what I'm going to do. This what I try and tell people is at some point in time, this moves from a legal issue to a mental health issue. And I think you're knocking right on that door because 15-year-old kids, you can't just grab them by the nape of the neck and throw them in the car and say, you're coming with me. And it becomes difficult. Even though they're minors, it becomes very difficult. But I don't like the unilateral nature of what I'm reading on some of these things. So what I'm going to do is I'm not going to touch physical custody, but I am going to refer legal custody to the front of the court for an investigation and recommendation and see if joint legal custody is still warranted. Maybe it should only be given to one of you, who would then make all the decisions relative to school, doctor's appointments, therapists, that type of thing. I don't know if that's the case, but I have to do a deeper dive on that. I can't decide that on a Friday morning. So the fees for that are $300. I generally split it if both parties are working. Are you working, Ms. Hernandez-Jackson?
I work, but I'm in an active Chapter 13, and I am bound to a budget. I am paying the child support. I am paying the motion for the extra medical care, but anything else, it would stress me to a point where I have a small child that I have sole custody of and take care of on my own.
Are you currently working, Mr. Jackson?
Yes, I work.
Okay. I think what I'm going to do is this. I'm going to prepare an order of reference. I will waive the fees for this Ms. Hernandez-Jackson, so neither party has to pay this. You should be hearing from the front of the court shortly. Once they complete their deeper dive in this, they can make a recommendation to me as to how we proceed. I think that's the only fair thing to do at this point. So it's nice seeing both of you. I wish your 15-year-old the best. This is tough business, especially with a 15-year-old. So we'll see if maybe the front of the court can give us some guidance on what should happen as far as legal custody is concerned. But you're all set, both of you, with me. Thank you. We're adjourned.
Thank you.
First on my screen is Blake Gilroy. Mr. Gilroy, good morning. You're on mute.
Good morning, Your Honor.
And next on my screen is Tanya Martin. Ms. Martin, good morning.
Good morning, Your Honor.
And our guardian ad litem in this matter, Attorney Stacey Van Dyken. Ms. Van Dyken, good morning to you.
Good morning, Your Honor.
So I have read all of these submissions. I have read Mr. Gilroy's motion regarding parenting time, as well as the response from Ms. Martin. I have read Ms. Martin's motion, and I have read the response from Mr. Gilroy on that one as well. It really is no wonder why this file is now 4 volumes thick from all the submissions I've received. So let's start with you, Mr. Gilroy. I've read your motion and I've read the response. Is there anything that you'd like to add before I hear from the other side and then from the guardian ad litem?
Yes, sir, and thank you for the opportunity. I respectfully submit this argument in support of my motion for 3 hours modification for young for parenting time and against all plaintiffs' requests for relief. Our daughter was just 19 months old at the time of divorce. She's now in early preschool, and I worked with the plaintiff to personally enroll Evelyn in formative extracurriculars. They include gymnastics, swimming, and roller skating lessons. Plaintiff has previously stated at our family wizard that she might not be able to make all of these to get the transportation figured out, but we successfully worked together, and I promise to fill any such gaps that our daughter might have in these types of activities. Our judgment of divorce grants both parents independent authority over routine and day-to-day decisions during parenting time. It explicitly prohibits interference from the other parent. It includes choice of attendance for special events, such as Yom Kippur, a full Yom Kippur experience, including a communal meal at a safe community gathering, serve our daughter's emotional and developmental needs, which have changed now that she is within 3. This change in circumstance since the entry of the current order, our daughter's evolving needs, and expanded opportunities for growth establish proper costs for this modification under the best interest factors. In March of 2025, Stacey Van Dyken recommended that I file this motion for the additional holiday parenting time. I genuinely believe that we could resolve a matter of just 3 hours, which may occur during my normal parenting time anyway, without extensive litigation. Furthermore, the GAL, after hearing arguments from both parties, instructed both of us that I could take our daughter to Hebrew school if I so during my parenting time if I so chose to. Furthermore, I yielded my parenting time for that whole week during Yom Kippur so that our daughter could have meaningful time with her mother. It's a very formal event, so I wanted to make sure she had like special girl time to get dressed and get prepared for this and have time for both of them to bond. I went even further than that and said, if you want to take her on a special shopping trip, you know, I'll reimburse you up to $100, get her a couple of dresses, a nice pair of shoes, whatever. Now, plaintiff did deny the shopping trip part of it, but it seems like she's on board with helping her getting around for this stuff. In total, my parenting reflects all statutory best interest factors. I foster age-appropriate cultural, educational, religious experience, supporting our daughter's autonomy, and I thoroughly have documented all co-parenting efforts. My legal filings fully comply with the rules regarding that everything I present is complete and accurate. Plaintiff's filings, on the other hand, repeatedly omit material facts and request authority beyond both what our judgment of divorce allows and what the GAL has recommended, including veto power over routine decisions and conditioning cooperation on demands unrelated to our daughter's welfare. These omissions and misrepresentations are in direct violation of that same rule. This isn't a first-time instance. On July 18th, lately, we've been doing like video calls between us. While our daughter is away for an extended period of time, we've been doing video calls, and that's been great. However, on July 18th at 5:39 p.m., our daughter was with her mother, and I got one such video call. It only lasted for 1 minute and 58 seconds. I was on my way to Temple to go to services. I told her daughter that. Our daughter asked a couple of questions, and the plaintiff started yelling at our daughter and demanded she hang up the phone immediately. I didn't intervene. I didn't stop. It wouldn't have been appropriate at that time. Our daughter doesn't need to hear us arguing, more so that's already happened. For Yom Kippur 2025, all of my parenting time falls under the existing continuous parenting time with our existing judgment of divorce. Plaintiff caused an issue with that and said that she needed to have a day in trade in order for me to get a full overnight for Yom Kippur, as the JOT already states. This has come long after we, both of us, successfully applied the same continuous parenting time principle for Thanksgiving 2024. In the same conference call in March 2025, Stacey Van Dyken warned us not to do this type of thing.
So let me ask you this, Mr. Gilroy. Your motion, and I read it pretty extensively, and this is what I know, that you have filed a motion for parenting time, and the last parenting time order was the party's judgment of divorce dated March 25 of 2024. And your request, very simple, is that parenting time be extended on Yom Kippur on the second day of the holiday past 6 p.m. for the communal meal. And the only change is that from the time the order was entered in 2024 until now, the child went from age 2 to age 3. Is that correct?
Not entirely, sir. I also moved between, at the time, like right around when we were entering that divorce, I was moving from Hickory Corners, Michigan, a little over an hour away, to Granville, Michigan. So that changed as well. We were trying to finalize a lot of those things. I was moving around that same time period.
Okay, but that really has nothing to do with this motion. It's requesting that I add 3 hours to your Yom Kippur, that it's not 6, that it's later. I'll hear from Miss Martin, and then I'll hear from Miss Van Dyken. Miss Martin?
I wasn't finished, Your Honor.
Oh, we're not going to try this case right now, Mr. Gilroy. I think I've heard enough on this. I've heard enough on this motion.
I just wanted to present that we've already agreed. We agreed in writing that I would get the 3 hours.
Well, that's why I'm off to Miss Martin. Right?
Sorry, apologies, sir.
Because if Miss Martin says that, then this motion's done, right? Miss Martin.
Hello. Specifically for Blake's motion, for this year only, 2025, I did agree to the extended 3 hours. Part of that is the continuous parenting time. I may have misunderstood that. Also, to abide by our current temporary order that's in place that sunsets in October. I'm also trying to be reasonable, even though I don't personally agree, which is probably evident from everything that's been filed, about assigning our daughter a religion. I'm also not, I'm aware that there has to be compromise here. And so that was my compromise. So I agreed to it in writing for this year only. After I said that is when I received Mr. Gilroy's response stating that now he wants it to be permanent and forever. And then if I do not sign a modification, a stipulated order, he would be filing to take me to court, which is why we're here. And I just said, I am not ready to say that this should be forever. The child is only 3. I've agreed to it temporarily this year. Let's just see and work together how this goes in the future. And you know, I don't believe that the child going from age 2 to age 3 has proven that threshold as to a change in circumstance. That seems like a pretty high bar, and from what I've been told, and just listening to your previous court proceedings.
Yeah, but you lowered the bar. You agreed to it.
Well, I had to, Your Honor. We have a temporary order in place.
You had to agree to it?
Well, otherwise I would be in violation of our temporary order.
Ms. Van Dyken, can you shed some light on this, please?
It's my understanding that Ms. Martin agreed to this year and this year only. This was, as the court stated, this was not an easy case to resolve at the judgment of divorce. Quite frankly, I believe my words were, you guys either need to figure this out or dismiss your divorce and start all over. So there was quite extensive discussions about religious holidays for Mr. Gilroy. And in the judgment, if that was going to be considered the additional 3 hours for a communal meal, it would have been in that judgment of divorce. We specifically listed the specific holidays. There was extensive discussions. I applaud the parties for working together and trying to resolve some issues, but it was clear to me that she had only agreed to this year.
Okay. Then we'll will you be preparing the order on this, Ms. Van Dyken?
Yes, Your Honor.
Then I will grant the motion for Yom Kippur 2025 only. Additional years will be by agreement of the parties, or if no agreement, they shall submit to mediation on that issue. Now, the second, more probable motion is the what I consider, and I've read it. I take it you got a copy of that too, Mr. Gilroy?
I did, Your Honor. Do you mean the one I responded to, Your Honor, or something different?
No, the motion that Tanya filed and you filed a response to.
Yes, sir.
Okay. I've read your motion and quite frankly, I really cannot give the parties advanced guidance on whether a particular activity violates the religious neutrality provision in their judgment. And I won't do that. Obviously, it's an interesting scenario. And I know Ms. Van Dyken, I think according to the information, it was you that that insisted on that provision. Is that accurate?
That is accurate, Your Honor.
Okay. Well, I can give you some guidance on that if the parties are willing to listen to that. So I'm quoting from a case called Fisher versus Fisher. So if you ever want to write that down, it's found at 118 Michigan Appeal 227, a 1982 case. And I'm quoting from the case, and it says as follows: once the purely secular decision of custody is made, okay, which it has been in this case, the parties made it, the court may not interfere with the religious practices of either the custodial or non-custodial parent, unless, of course, those practices threaten the children's well-being. The court may not order the custodial parent to educate the children in a particular faith, just as the non-custodial parent's right to pursue his or her religious activities and to involve the children in those activities during legal visitation periods cannot be violated. That was the case of Hilly versus Hilly, and that was out of Alabama. So religious neutrality, what it really means is the refusal by a court to intervene in the absence of a showing of harm to the child reflects the protected nature of religious activities and expressions of belief, as well as the proscription, which I'm sure Ms. Van Dyken was getting at, against preferring one religion over another. So that's what the religious neutrality clause means. It means that I can't stick my nose into either parent's raising of this child in their particular religion unless there's an allegation of harm to this child or children. So that is really what this amounts to. Now, I will tell you that I don't know if the parties will ever be on the same page because, quite frankly, I've had cases where parents have taken children to temple and also to the cathedral. And that's the way it works. And then at some point, either the parties say, you know what, this is not doing anybody any good. That usually works when the parties are in a little bit better spot than where this case is. Or the child will somewhat say, hey, look, I'm interested in being confirmed. I'm interested in going through the Jewish faith, whatever. But this court cannot pick and choose sides. That's what Ms. Van Dyken was referring to with the religious neutrality. Ms. Van Dyken, is that about spot on?
About spot on, Your Honor. To clarify as well, it was also about not listing the child as any religious affiliation on any documents as well.
Yeah.
And that was in addition, so.
Yeah, I mean, so when the child goes into the hospital or something, or to the doctor, and they go religious preference, the parties can either list them both or put non-denominational, whatever they want to do. But that's where the religious neutrality goes. So that's how I can best answer your motion, Ms. Martin. I can't give you any advance directive as to whether this or whether this or whether this would violate that clause, because number one, it hasn't, there has to be another link to it. And it would be threatening a child's well-being. And I don't know how any religion could ever threaten a child's well-being, but go ahead.
I appreciate your answer to help kind of clarify things. And I'm not trying to be overly redundant. And I realize that I just, around schooling, whether it's religious school or not, right? We have to be on the same page under the terms of joint custody.
Exactly. But I will tell you this, and this is something you both might have to realize, is that after a few of, let's say, school issues, let's say doctor issues, therapist issues, these types of things, after a few of those, I am going to be in a position of having to find that one of you should not have that authority anymore. And that authority would be exercised by either Miss Martin totally or Mr. Gilroy totally, and not as joint custodians. And that not only involves religion, that involves doctor's appointments, therapy appointments, the ability to participate, to get all the records, all that stuff. And that's a very, very dark road to go down, but unfortunately one that I can really see is on the horizons for both of you, unless you two make some sort of concerted effort to get on the same page with this stuff. That's all I can tell you. But you're right, they have to agree on major decisions. But religious, going to a particular church or going to participate in religious activities is a decision that a custodial or that a visiting parent has, just as much as you have that. That's not anything that can be decided. So I'm all set, Ms. Martin. I can't keep going through question and answer sessions. Can you prep that order, Ms. Van Dyken?
I just want to, there was one other issue Ms. Martin raised about service, and I can direct the parties to the court rule with regard to service and our local administrative rule as to service via email.
I didn't, yeah, I thought that was.
It wasn't presented before the court, but it was an agreement we made, Your Honor.
Okay. All right, Ms. Van Dyken, will you prepare that?
Yes, Your Honor.
Ms. Martin, is this going to keep going on and on and on and on?
No, Your Honor, I'm just trying to ask about the email thing. Is it a 7-day or a 9-day notice?
Email is 7 days.
Okay.
Oh, yeah. And believe me, if you two need to, if this case is ratcheted up that high, then you have bigger problems than I can figure out. We're adjourned. Thank you.
Thank you, Your Honor.
We're gonna do number 11 next. Case number 1908418 DO Stokes versus Stokes. I do not believe we have the plaintiff.
No, he couldn't make it. He's at work.
All right. You are, is it Montania?
Matania.
Montania Stokes. Ms. Stokes, good morning to you.
Good morning.
And you indicated is Mr. Stokes going to be joining us?
No, he couldn't make it. He's at work.
Okay. But he knows about this, yes?
Yes.
Okay. Let me tell you what I know. This is a renoticed motion from February 14 of 2025. I heard motions on this case on February 16 of 2024 and of May 24 of 2024. And this matter could quite frankly have been concluded a long time ago, but the parties keep not appearing for court hearings. Is there any reason why things are taking this long?
The one that happened on the 14th, I didn't get like the final notice of the court that day. When I went in, they didn't tell me to go to the second floor. I forgot about that part of it. So I didn't get to the second floor part to get the actual court, the date and time or whatever.
Okay. So I need, I know there's genetic testing in the file and that the defendant is not the father of JLB, date of birth 4/16 of 24. Is that your understanding?
Yes.
Okay. So let me tell you the final step. All right.
Okay.
Only one more. You're almost there. Pursuant to MCL 722.1443, parent 4, I have to have a short half-hour, what's called best interest test. I have to take some testimony from you and Mr. Stokes to make sure that my declaring JLB born out of wedlock is in his best interest. So that takes about a half hour, but I'm going to need you and Mr. Stokes there. Okay, it'll be by Zoom, just like we're here today. Okay, so we'll go ahead and set that up for you, and you can pass along to Mr. Stokes that he needs to be there as well.
Okay.
And then we'll get this done for you. Okay.
Ooh, okay. So much.
You bet. Take care. You can sign off, and we'll send that to you if my clerk has your correct address. I just want to make sure that.
Okay. Appreciate it.
You bet.
Thank you. Bye.
And this is number 14. Case number 2200629 DC, Williams versus Reynolds. No appearance by the plaintiff.
Okay. You are Rochelle Reynolds?
Yes. Hi. Good morning, Your Honor.
Good morning. And how it indicates here, at least on your motion, that you sent a copy of this motion to Mr. Williams on September 2 of this year. Is that true?
Yep. It's 35 mil. Yes, Your Honor.
Okay. Did he get it?
Yep.
All right. He just.
I have not confirmed with him, but delivery, yes.
Okay. So I read your motion, and the last parenting time order was this court's order for custody, support, and parenting time dated July 1 of 2022.
Yes.
And plaintiff has parenting time each Wednesday from 7 to 5 and each Sunday from 11 to 7. My question, I have a couple of questions. Is the status of both the CPS investigation and the law enforcement investigation?
So the status for CPS, my caseworker, her name is, give me just a moment, Holly. She called me yesterday saying that she was, her attempts of reaching out to Mr. Williams are unsuccessful. So she asked me for his mother's phone number because currently he is temporarily staying with his mom. So I gave her mom's number and she contacted mom and said that she would be heading to the house. She told me to get back in contact with her today after court to let her know how court went. And that's it as far as like CPS, because she couldn't get into contact with him. So I don't know the update as of right now, since she spoke with him or went to the house yesterday. Via the police report that I made, it was not an investigation that was opened up, just a report that was made, and I got the case.
Are they going to issue criminal charges on that?
I have no idea. That was not related to me at all.
Okay. Because normally before I do the things that you're asking to do, wait for all these investigations to be done.
Okay.
Okay.
Yes.
Because the statute essentially says that, and this is why I have to wait till they're done, is MCL 722.27A3 states that I need clear and convincing evidence to suspend parenting time.
Yes.
And I got to wait until CPS and or law enforcement finishes that up. So what I'm going to do is I'm going to, so you won't have to pay another fee, I'm going to adjourn this motion without date. And once CPS and law enforcement conclude their investigations, I want you to bring it back to me and tell me what they came up with. And then I'll be in a better position to address what you're asking me to do. Okay?
Okay. Yes.
And also, I want you to think of one other thing while you're figuring this all out. If I were to do something like supervised parenting time, do you have a supervisor in mind who you believe would be a proper person, or do you think this needs to happen at a facility like Safe Connections, Journeys, that type of thing?
I can think about that.
Okay.
I did not think that far.
Yeah, that's good. That's fine.
Okay.
That way I'll give you a chance. But when we get back together, if you'll have a little bit more information as far as what's going on with CPS and what's going on with law enforcement, and then I'd be in a better position to make a decision on this. Okay.
Okay. Yes, Your Honor. Thank
All
you.
right. You are all set with me.
I just have one thing to say. I put it in the motion that I said that RW will not be coming back at this time. And I also want to say for the record that we have not adhered to the specific parenting time established, just because he changes jobs all the time, and he's inconsistent with when he picks up or decides he wants RW. So I did state though that I would not be given RW back, and I know it's violating, or I just want to know, do I have to until all of that is?
All I can do is this. All I can tell you is this: is that everybody has to follow court orders to and including courts, right? So does that kind of give you an idea of what you got to do?
Yeah, but
Okay.
Wednesdays. Okay. She's in school now, so the days are a bit different, honestly, so I understand what you were saying though. I appreciate it.
All right. You take care, and I'll see you soon, I think, right?
Okay. Yep, I will. As soon as I get everything sorted out with them, then I will put that information back in to file the new motion.
Perfect. Sounds
All
good.
right.
Thank you very much. Have a good
Thank
weekend.
you. You too. Bye-bye.
Next is going to be number 9 on our list. That is case number 1910165 DP, Syed versus Malika Rajuna.
Okay. Let me see if I can get all the people together here. You are, is it Chandra Syed?
Actually, I've been trying repeatedly to have my name updated. I'm in the, it's been Nyhoff for the past year,
Okay. Have,
but yeah, Saeed Ahmad is what it was when I filed initially.
how do you wish me to refer to you today?
Just Nyhoff is the last name I'd like to use.
Okay.
Nyhof as in Frank.
Okay. So Ms. Nyhoff, what you would have to do, I don't know what steps you've taken to square that up with the clerk's office, but that's probably where you would have to go. And they can help you out there, maybe.
Yeah, I filled out that form multiple times.
Well, then you can
Okay.
get a live body down there, and hopefully they can help you out. And I'm gonna mispronounce this terrible, but is it Mr. Mallikarjuna?
You're almost there. Yeah.
Wow. Well, good morning to both of you folks.
Yes.
I read the motion and it looks like what you're trying to do is trying to deviate from the court child support amount. Is that what's going on?
Yes, we were trying to have it just remove or reduce down to the minimum amount for the state. Just because we at the moment need to keep our Medicaid because my son gets sick a lot. Our son, I guess, gets sick a lot. So we just need the Medicaid until he's able to get a job that offers medical.
Okay. I think the reason the court rejected your stipulation is because it needs more information. Okay, so what I'm going to do is make it easy on both of you. I'm just going to have send it over to the front of the court and let them do it. Okay, that seems a lot easier to me to
Okay.
get done with. Okay.
Okay, yeah, they're the ones that told me I had to do it this way. They've
Yeah,
been
well,
being very
I'm kicking it back this way to them
Okay.
because then they can fill out the proper forms when you meet. And then you guys can discuss it with them before they actually do a full-blown investigation. That way,
Okay.
straighten it up that way. So I'll do that order right now. Okay.
Okay. Yeah, they've just been very difficult with us.
Yeah,
And I'm in Ann Arbor now and he's in Texas. So it's just been hard to get down there too.
Well, they'll do it
Up there.
Yeah, up there. They'll do it on Zoom.
Okay.
Very easy. They'll do it on Zoom, and the reason why it's tough is because if there was no general assistance, no Medicaid, no nothing, then you could do this in a snap. The
Right.
problem is when you have that, if you don't do it right, the state, the Department of Health and Human Services will reject it. And I think that's what they want to make sure doesn't happen.
Right. Yeah, we're working on getting off of the state assistance. It's just I
That
lost
was-
my job right
Yeah.
after I started this.
That would certainly solve it, but until then, we'll have the friend of the court help you out. Okay.
Okay. All right. Thank you so much.
Nice to meet both of you. You're all set, and you can both sign off.
All right.
Thank you.
Thank you.
Thank you.
Move to number 1 next.
There we go. First on my screen, the defendant in this matter, Robert DeCam. Mr. DeCam, good morning.
Good morning, Your Honor.
Next on my screen is the plaintiff in this matter, Sasha DeCam. Ms. DeCam, good morning.
Good morning.
I have read your motion, Mr. DeCam, and you got a copy of that as well, Ms. DeCam?
Yeah.
Okay.
Very, very late, but I did get a copy.
Okay. And you received, I received your response as well, Ms. DeCam. Did you get a copy of that, Mr. DeCam?
Yes, I did.
Okay. So everybody has everything. I'll turn things over to you, Mr. DeCam. Anything in your motion you want to tell me before I hear from Ms. DeCam?
No, I would just say that I filed a motion because there is currently no parenting time required. It's something that we've agreed upon through mediation through the judgment of divorce. Paragraph 11 says that we will be doing this reasonably and mutually agreed upon by the parents, and I don't believe that's been fulfilled. I don't believe it's mutually agreed upon by the two of us at this time.
Well, it's somewhat vague, right? I mean,
Correct.
if the court order that is that parenting time will be as the parties agree, then if the parties don't agree, there is no parenting time, right?
That is correct.
Okay. Mr. Cam, what can you shed on this? I read your response.
What can I what?
You want to shed any light on this for me?
Sure. We have originally, when we went through mediation, there was quite a lot of conversations, a lot of agreements that he has not held up to. I originally was planning on him having the kids one evening a week, unless they had other activities or things going on where that wasn't possible. I'm not very comfortable with him having the kids in his car just because of his history with alcohol abuse and getting multiple DUIs and telling me that he doesn't believe he has a drinking issue. So I feel it's a safety matter.
Well, let me ask you this. According to your response, at least it looks like to me anyway, that most of those issues occurred long before you and him signed a an October 30th, 2024 stipulation. Is that true?
I believe his last DUI he was still under probation at that time.
Okay.
Or maybe he had just ended probation.
Well, see, my point is this. I can consider changes of circumstance since the last order. And the last order is clearly October 30th of 2024. And anything that occurred before that, it's not irrelevant. I don't want to say that because obviously if it's an ongoing situation, that can be problematic. But it looks like to me is the parties just can't seem to get out of the starting gates on this stuff. And I certainly can't decide that on a Friday morning. But I will tell you that pursuant to Shade versus Wright, 291 Michigan Appeal 17, a 2010 case, I have to have at least proper cause or change of circumstance to stick my nose into your parenting time business because most people don't want courts involved in their lives. But poor communication or lack of cooperation between parents does constitute a change of circumstance to revisit parenting time because the relevant best interest factor, MCL 722.23, J as in Jimmy, diminishes each parent's ability to encourage a close and continuing parent-child relationship between the other parent and the child. Those was set forth in an unpublished decision of Bauman versus Hartman, which obviously is not binding for stare decisis purposes on me, but is persuasive. So my only recourse at this point is to reopen parenting time, send it to the friend of the court for a complete investigation and a recommendation. Mr. DeCam, are you currently working?
Yes, I am.
And Ms. DeCam, are you currently working?
Yes, I am.
Okay. So the fee for that investigation and recommendation is $300. It'll be split between the parties. What they will do is they'll meet with both of you before they do anything, and it'll be by Zoom. And they'll see if they can't come up with an agreement that you both can live with, I guess. And if you can't, then they will conduct a full-blown investigation. Both parties have to fill out questionnaires. They will talk to whomever witnesses you wish them to talk to. They may talk to the children, they may not. And at the end of the day, they will make a recommendation to me about what parenting time should be, and the parties can accept it. And if that's the case, an order would be entered and it would be done. Or they can reject it, and in which case I would have to, like my last one, have a evidentiary hearing, a trial on what I believe parenting time should be. So that's kind of where we're at this point in time. I'll get the ball rolling for you guys. But I really hope that when the friend of the court meets with both of you, which usually is in a couple of weeks, that they can come up with an agreement and put an end to this thing. But if not, we'll run a complete investigation. Okay? That's what
Perfect.
I can do for you. All right?
Thank you, Your Honor.
All right. Thank you both. And make sure the friend of the court has your current addresses and all that. If there's any doubt in your mind, go over there to 82 Ionia and make sure they have it, because they don't forward mail. And I don't want anybody getting lost in the problem. Okay.
Thank you, Your Honor.
Good luck, both of you.
Thank you.
You are Javon Doer.
Yes, sir.
Good morning.
Good morning. How are you?
I'm well. You too?
Yes, sir. I am well. Thank you.
And Mackenzie Doer joins us. Ms. Doer, good morning.
Good morning.
So this is your motion, Ms. Doer, relative to custody. I have read it. Did you get a copy of that, Mr. Doer?
Yes, sir. I did.
Okay. Then anything you want to add, Mackenzie, before we hear from Javon?
Your Honor, this should be the motion regarding custody was withdrawn. This should be a motion regarding parenting time.
The only thing I have in front of me is custody, but if you want to argue parenting time, you can go right ahead.
Okay, it basically deals with the same thing, the abuse of BJD. It's kind of been a year leading up to this. I've always planned to ask for a change in parenting time, just because the concerns of neglect that I've had for my children, I've brought up with Javon frequently over the past year, and nothing has changed. Things have just gotten worse. When I say neglect, I mean things like not showering or brushing teeth during his parenting time, not having products to do their hair, lack of adult supervision, bedtimes. My kids are struggling emotionally. They feel like they can't even speak freely to me anymore because they get in trouble. They bring me these concerns. I try to speak to Javon about it, and then they get in trouble. one incident, particularly it was BJD was left home with his younger brother, and I think an older child. They could not get in touch with their dad, so he did what he knew to do and called me. After I also could not get in touch with dad, I went and picked him up, and tried to get in touch with Javon for over an hour. When the kids were returned, Benjamin was spanked and had Xbox taken away and told never to do that again. He was in trouble for asking for help when he felt uncomfortable.
Let me ask you a question before we go.
Younger, yeah.
You put in this motion that first, Child Protective Services is currently involved, and second, that Mr. Durr has been charged with child abuse in the 3rd degree. Is that true?
Correct. Yes.
Okay. All right. Well, that belies more questions. So, has he been to court yet on this child abuse 3rd degree?
I am not sure. That would be a question for him, I think. I know he had an active warrant. So I know he went to jail for a short time. I don't know that he's been to court.
Well, and the reason I'm asking is this, is whenever someone's been charged with a criminal offense relative to children, what the court will generally do is they will put a bond condition on contact with children. And that's what I'm trying to get to the bottom of, because if there's a bond condition.
If I may, sir, I just want to update you on that. So
yeah, please go ahead.
I do currently have a lawyer. Her name is Thea Brock. She is currently handling that criminal case currently for me in the 63rd District Court. There were bond conditions set. As far as parenting time is concerned, they referred it to CPS's guidance. I have spoken with Madison Bailey, who will actually be here again today for another appointment, just to meet with me and my significant other as well. They don't recommend any changes or removal from the home or any change in parenting time or anything like that. They've already experienced a interaction with us when I picked them up from school. They were there to experience an interaction and decided they didn't want to interview them at that time. There was no need to speak to them. There's been no need for anything to change, Your Honor. And if anything is to be done and any decisions are to be made, I would at least like time to at least adjourn, so that way I can have time to get a lawyer, so that way I can provide the necessary evidence that's necessary to prove as to why these are all simply allegations against me. And
well, I know what they are. I mean, you haven't been convicted of anything. I agree with you.
Yes, sir.
That's really not the where I'm at as far as that is concerned. Where I'm at is that while the criminal justice system works its way through these cases, I don't want to do anything that's going to put either you in legal jeopardy, put Mackenzie in legal jeopardy, or your kids in any type of problems.
Yes, sir.
So one of the things that I would like you to do, I will adjourn it because I have a lot of questions. Because I have never heard of a case. And I think, Mackenzie, have you been in touch with anybody from CPS at all?
Hardly. The last update that I had from them was just that his case was substantiated and ongoing.
Okay, I need you to contact them and get me a status. And then I need you to contact the victim witness in 63rd District Court and find out if there's any bond conditions. Because
Your Honor, I spoke with the victim's witness yesterday, and she was surprised that there was a no contact order put into his bond.
Yeah, I
There
mean,
was initially put one upon release, and then when I went to the arraignment initially, the judge referred the guidance to CPS because there wasn't anything. This is all like I said, this all just happened so fast, Your Honor, and there
okay,
was
well, that makes sense.
change.
I'm gonna adjourn this for 2 weeks, and I need some answers, and Mackenzie needs some answers. And I think you need some answers. I need you, Mackenzie, to contact CPS. I want to know what's going on a substantiated physical abuse case of what they're doing as far as this thing is concerned, because none of this makes a whole lot of sense to me. Usually in a case of that's charged anyway as child abuse third degree, at least they're going to have a no contact bond, because that could amount to allegations of, not that Mr. Dewar would do this, but it could amount to allegations of witness tampering, that kind of stuff. So normally they will put a no contact order, and boy, I'm with you. I'm shocked that there isn't one. And but I think if they deferred to CPS, I need to have you talk to CPS and tell me what's going on here, because this is going to be that's going to really drive the bus here. Once CPS is involved and once criminal authority is involved, usually the family law case takes a back seat until all that's figured out. So I want to.
If I may say, the caseworker, her name is Madison Bailey currently. It is going to change because it is going to ongoing. But her and her supervisor, they did leave me a paper as well that states that what I'm to do, no physical discipline, take him to the hospital if he needs, basically stating that they weren't excuse me, I'm sorry. Basically stating that they weren't intervening as far as the parenting time is concerned, and I can send that over to you in an email or something if necessary.
Well, I need Mackenzie to have that.
Oh,
and
okay.
you can submit that to me, not in an email, but in a response to her motion, because
I can just leave it up to her to do that at this point, Your Honor.
I'm just real troubled by the fact that the mother of these children is not in the loop, and that's bothers me because CPS should be on, her number should be on their speed dial, especially as the custodial parent.
Yes.
So now I got to.
I'm not trying to downplay the situation by any means.
No, I know.
The reason is because they just don't see any. They've like I said, they've witnessed interactions. They've spoken to us. They haven't seen any severe reason. Like I said, when they came to the school, my sons, they both ran up to me smiling, jumped on me first day of school.
Yeah.
You know, so
All probably, I have no cause to doubt you, but
yes,
I have to follow a legal process, and I don't like the fact that that the plaintiff, one of the custodial parents, is out of the loop on this. This kind of is odd to me. So
yes, sir.
you can renotice this, Mackenzie. You won't have to pay any fee to do that, but I need to know what's going on in the CPS case and in the criminal case. Okay.
Right. Your Honor, I have one more concern, just regarding the inherent rights of the children. I am not able to co-parent with Javon. He has blocked me completely. When he began his parenting time on September 5th, he also blocked the children from my only line of contact, which is their iPads. I spoke to them one time for 38 seconds.
Okay.
And have been blocked.
Stop.
Sorry.
Both of you are joint legal and physical custodians.
Yes. Correct.
Unblock each other now. Okay?
Yes, sir.
Unblock it now. Both of you. I want her to be able to contact the kids anytime, and I want you to be able to contact the kids anytime. Okay? I can't get any clearer than that.
Yes, sir. Is it fine that I have my spouse unblock her and she go through my spouse for communication?
You're the custodial parent. gonna go through you.
Okay.
I appreciate your spouse's involvement, but that is gonna change, and you can bring this back. As I said, there doesn't have to be any a new fee paid, but I need to know what's going on here, okay?
Yes, sir.
All right, thank you both very much, and boy, I hope this gets straightened out. What a mess.
So, Your Honor, how do I go about, what do I need to submit to you? I
No,
just go to,
go to
I'm
the
sorry, go ahead.
go to the Legal Assistance Center again. But I
Okay.
need you to contact CPS. I need something from a victim witness that says there's no conditions, bond conditions prohibiting contact. I need all this information there, but you should be on the horn to CPS like yesterday. Okay?
Okay.
You both are all set. Thanks.
Thank you.
Next is gonna be number 4. And that is case number 2301424 DS SB versus Murphy.
I see Miss Epsy.
There we go.
Nobody gets the attention quite like a motion.
Yes, sir.
Miss Epsy, good morning to you.
Good morning.
And Mr. Murphy, good morning to you.
Good morning, Your Honor.
So I read your motion, Miss Epsy, or Espy, I'm sorry. Did you get a copy of that, Mr. Murphy?
Yes, I did, Your Honor.
All right. Anything you want to add to it, Miss Epsy, before we hear from Mr. Murphy?
No.
Mr. Murphy, you got the motion. Is there anything you want to add to it?
Your Honor, honestly, I would just like to say that, sorry, we're here because this is honestly something that we could have got through ourselves because we've been doing week on, week off, for the last 2 months. I was recently just put in jail, but even before that, we were doing week on, week off, and I just want this to continue and just kind of let go of all the disrespect and social media stuff. We have a little girl that we're raising, and I would like for her to see that parents can get along.
I'd love nothing more than that, but something tells me Miss Epsy is going to take issue with some of those things.
Of course.
Miss Epsy,
Yes.
thoughts?
Thoughts is that when he got out of jail, he was recently incarcerated. Excuse me. I'm 9 months pregnant, so he wants to do a week on, week off, which is cool with me. She just started school, so I wanted to change the week on, week off from to her being with me Monday through Thursday because she catches the bus to school, and he wants to pick her up and drop her off, which she catches the bus. My daughter has structure when she's at home, so I want him to do Thursday through Sunday, and he can get her on the breaks or the days that she has no school. I just recently started a new job, and I asked him to keep her over for more than over a week because I wanted to finish my training days, and then she could have came back home. He got mad at me and told me that I needed to add his girlfriend to her pick up and drop off list because I don't know what reasons, because he's working. If he's working, then I'm supposed to be getting child support. I haven't received any child support since last year. He doesn't report that. He doesn't communicate. I have to communicate with his mom. When my daughter is with him, I try to call, try to check on her. He doesn't answer. It's just too much inconsistency. And I don't have time for that. I'm gonna have another baby, and I'd rather for my daughter to have structure and stability than somebody that's inconsistent and that want to keep coming in and out her life. I deal with her emotionally, physically. My daughter has asthma, so when she's sick, he feel like he doesn't have to deal with her and he doesn't have to show up to anything. And I just feel like that's not fair to her because she's 3 and she knows.
Are you currently working?
Yes, I'm currently working.
Okay, Mr. Murphy, are you currently working?
Yes, sir.
All right. I'm going to have the front of the court get involved with this because they're going to have to make a recommendation to me relative to what parenting time should be, because apparently, although you got the best of intentions, it's not working that way. So I'm going to say,
If I
what more can you tell me, Mr. Murphy?
honestly, it's not the way that she's making it seem. It's a lot of harassment. I have a new girlfriend, and she's been in my child's life since she was literally day one. Like, and honestly, it's a consistent thing. Like, she makes it very hard upon me. She threatens my mom, my sister, which is a person that has special needs, with
Yeah, I
taunting.
mean, this is why we need in writing what your parenting time is going to be.
Your
And
Honor.
you can do that. No, I'm done with questions, Mr. Murphy. You both cannot do it. You're incapable of it.
Yes, sir.
You both cannot do it. And it's not your fault, Mr. Murphy. It's not your fault, Miss Espy. You guys are just like oil and water. You don't mix. So the only way that when two parties have a child, the only way that you can get a parenting time order so everybody knows what they got to follow is if the parties come up with one, which doesn't sound like that's going to happen, or the friend of the court makes a recommendation to me, and that's the only option I have. So I'm going to send it there. Make sure the friend of the court has your correct address. It's $150 a piece to for the FOC to investigate, and I'll send it there today. And make sure they got your correct addresses, and the parties can always get together and come up with their own game plan. But it sounds like someone's going to have to step up and make the decision for you. So that'll be me. All right.
So we
I
have to
appreciate it, Your Honor.
go back through the FOC and then return back to you.
Well, it depends. The FOC can resolve it for you too. They might be able to resolve it where you both couldn't. Maybe they'll give you a hand. But if you can't, if there is nowhere to solve it, then yeah, then it's got to go to the then they have to make the recommendation, and then the parties are free to accept it. If they don't accept it, then I got to make the call, and then I'll have to have an evidentiary hearing. Guys, it'd be a big trial and requirements and briefs and witness lists and all that stuff. And you two can, like I said, you two can avoid all that. Just get together on the same page and figure something out. But until that happens, I'm sending it over to the front of the court. All right.
All right. Thank you, Your Honor. Appreciate it.
That you're all set. Thank you both.
Let's move to number 6. And this is case number 2311033DS, Hovis versus Signs Spell.
All right. Looks like first on my screen is Tanner. It says Tanner Spell. Mr. Spell, good morning to you.
Good morning, sir.
And Lexia Hovis joins me. Ms. Hovis, good morning to you.
Good morning.
It looks like this is your motion, Mr. Spell, for parenting time. I have read it. I've also read a response from Ms. Hovis. Did you get a copy of that, Mr. Spell?
Yes, I have it.
Okay, then I'll start with you. Anything you want to add before I hear from her?
Not really. Just kind of basically go over the whole reason for why I filed a motion was basically just because there was a period of time around a month where I hadn't seen Corbin, and we had been following the schedule that was currently already in through the friend of court, and it had been going good since it was filed, and just recently there had been a problem. Since then, I have seen Corbin for the past couple of weeks. We've been doing a different schedule that kind of works better for based off like my work schedule and her work schedule, and gives me more time with Corbin and not having to kind of rely on someone else on the weekends, which is my current work schedule right now.
So you both have figured it out yourselves?
I mean, I wouldn't say we fully figured it out. We have a agreement that we kind of just been mutually agreeing on to work through just until up to now, and just kind of going with that as is.
Well, I mean, I'm not going to stick my nose in it unless I'm asked to. And it sounds like you both have come up with your game plan here. And all I can tell you both is to make sure it's in writing and follow it, because if it's in writing and the parties are not following it, then what you have to do is you have to file parenting time complaints with the friend of the court, and then they will bring it back to me if they find it necessary. And then the friend of the court, if they find one of you is in contempt, then they can put fines on. They can do make up parenting time. They can actually put people in jail. And I don't want any of that for you two. So follow the written order, I guess, unless you guys change it. Does that sound like a plan?
Yeah, I mean, it sounds good with me. I'm not sure if she has anything else to add.
Ms. Hovis?
Are you suggesting that we return to mediation and get the newly mutually agreed upon schedule in writing?
You don't need to go to mediation for that. You can go to the Legal Assistance Center and draft up what your new schedule is. And both of you sign it, and then it becomes an order of the court once I sign it. I'm only doing that for both of your protection, because if you don't, then there's nothing to enforce. So if you go to pick up your child and he's not there, then problems develop, and vice versa. If you're not there when he comes to pick up, then so yeah, and all parenting time agreements should be in writing. That's where all the problems start, when they're not. Okay. I always say that oral agreements aren't worth the paper they're printed on, right? So you don't have to go back to mediation. Just go to the Legal Assistance Center. They'll give you a form. You both write out what your agreements are, and both sign it. They'll send it to me. If it looks good to me, I'll sign it, and then you have a court order. Sound like a plan?
Yeah.
Yep, sounds good.
I wish more were like you two. You guys are shining stars today, because some of these people can't even agree that their first name is Tanner. But you guys have all right, good example of that. So thank you very much. So you can both sign off, and we're adjourned.
Moro versus Noel.
Okay. It looks like I have Mr. Noel here, and Miss Umoro. Let me ask you, Miss Rummel, when you had your case conference, couldn't the interpreter be at that case conference and sign these documents necessitating, which would, I guess, not require us to have a hearing on this? Is that not done, or is that possible, or?
That's absolutely done, and that's what we attempted to do. Mr. Noel is very averse to paying any support. Miss Yuamahoro requested a medical support only order. I attempted to explain that to the parties, but because of the defendant's resistance, it was very hard to interpret that. After our hearing that was attempted 2 weeks ago, but we didn't have an interpreter.
Right.
I again tried to call the parties and explain what had happened and what I'd like to do to see if they would sign a consent. They would answer the phone. I called them both twice. They would answer the phone. I'd introduce myself and they would hang up. So I was unable to explain what we're trying to do here to them today.
Okay. Okay. Well, it sounds like you gave it your shot.
I did try. I was not successful, but I did try.
Ben, good morning.
Hi.
Madam Chair.
Yego.
Hey, Ben,
Good
can you
morning.
unmute and raise your right hand for me, please? You solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge any confidential communications.
Yes, I do, Your Honor.
Thank you. For the record, I believe Ben is a qualified Kinyarwanda interpreter and has interpreted in many cases with me. I'm very pleased that he's here. So thank you for helping us out today, Ben. And once again, good morning.
Good morning, sir.
And could you tell Diane and Mr. Noel, good morning from me.
Mwaramutse Noel na Diane, umucamanza arabasuhuza.
Yego.
Mwaramutse. Good morning.
All right. Let's plot through this.
Where's Mama?
All right. Why don't we let's mute the parties if I could. I'm gonna makes it a little easier to. All right. So a complaint for child support was filed on May 28 of 2025.
Handitswe ubusabe bwo bwa child support ni ukuvuga mu mafaranga afasha umwana mu kumurera ku itariki 28 z'ukwezi kwa gatanu 2025.
It was served upon Mr. Noel on June 5 of 2025.
Ku itariki 5 z'ukwezi kwa gatandatu 2025 nibwo Noel yabikoze.
Mr. Noel filed an answer on June 6 of 2025.
Ahubwo nibwo Noel yabyohererejwe ku itariki 6 z'ukwa gatandatu. Noel yohereje igisubizo.
A pre-hearing conference was scheduled on August 4 of 2025 at 3 p.m.
Hanyuma haba urubanza rw'imbanziriza rubanza ku itariki 4 z'ukwezi kwa munane 2025 saa 9.
The child support as originally calculated by the people
ubundi busanzwe amafaranga yo kurera umwana child support urugero rwayo rushyirwaho n'abantu
for 4 children
ku bana 4
$699 in base support
bikaba $699
$40 in ordinary medical
hakaba $40 ajyana n'iby'ubuvuzi
for a total of $739 per month.
Yose hamwe akaba $739 ku kwezi.
When there are only 3 children involved in this case,
kubera ko muri iki kibazo hagaragaramo abana 3 bagomba kurebwaho,
support would be set at $655 in base support.
Amafaranga y'ibanze agomba gutangwa azajya aba $655.
$30 in ordinary medical.
Noneho ku buvuzi hakaba 30 buri kwezi.
for a total of $685 per month.
noneho buri kwezi yose hamwe akaba $685 ku kwezi avuye kuri ya yandi twavuze mbere.
When there are only 2 children subject to the order,
mu gihe baba ari abana babiri rero barebwaho muri iki kibazo,
the support would be $611 in base support,
ay'ibanze agomba kuba $611,
$20 in ordinary medical,
$20 iyo ajyana n'ubuvuzi,
for a total of $631 per month.
noneho yose hamwe akaba $631.
And when there's one child associated with this case, support would be $522 in base support.
Mu gihe rero yaba ari umwana umwe gusa urebwaho muri iki kibazo, hajya hishyurwa $522 y'ibanze,
$10 in ordinary medical,
hanyuma hakaba $10 y'ubuvuzi busanzwe,
for a total of $532 per month.
noneho yose hamwe akaba $532 ku kwezi.
The incomes for the parties
hanyuma ku bijyanye rero n'ayinjizwa n'abari muri uru rubanza,
for plaintiff was potential income,
kurega ahangaha ku bijyanye n'ayo yinjiza,
and I have considered the factors set forth in the Michigan child support formula.
hanyuma ndagira ngo bamenyeshe ko mbere y'uko mfata umwanzuro ahangaha nashingiye ku mabwiriza akurikizwa mu mategeko ya Michigan kugira ngo atuyobore mu gufata icyemezo,
specifically section 2.01G.
cyane cyane mu gika cya 2.01G.
And I find imputation proper.
hanyuma nsanga icyemezo kigomba gufatwa gishingiye kuri iki gika kigomba kuba kimeze neza.
For defendant's income,
ku bijyanye n'ayo uregwa yinjiza,
actual income was used.
ku yo yinjiza hafashwe ya yandi umushahara nyirizina.
There are 0 overnights used in the calculation.
Ubundi aya ngaya umuntu ayabona hakoreshejwe urugero rwa 0.90.
And the uninsured medical percentage split
hanyuma ku bijyanye n'ubuvuzi urugero rugashyirwaho hashingiwe ku buvuzi budafite ubwishingizi.
For plaintiff 40%,
kurega bigashingira kuri 40%,
for defendant 60%.
hanyuma kuregwa bigashingira kuri 60%.
However,
ariko
pursuant to the Michigan Child Support Formula Manual,
ariko dushingiye kuri departement, ni ukuvuga igisata gishinzwe gukurikirana ukwishyura amafaranga yo kurera abana muri Michigan,
section 1.04E,
ku gika cya mbere akadomo 04E,
application of the Michigan Child Support Formula,
ahangaha bikaba ari ibintu bishingirwaho kugira ngo hakorwe umubare nyirizina w'agomba kwishyurwa yo kurera abana
would be unjust or inappropriate
dushingiye kuri iki gika ntabwo igisubizo cyaza kimeze neza
pursuant to section 18 of those guidelines.
Dushingiye ku gaka ko muri iki gika agaka ka 18.
Therefore, child support shall be
ubwo rero dushingiye kuri ibyo byose amafaranga yo kwishyura nako yo kurera abana child support azaba yakurikira
effective August 1 of 2025
kandi bikazatangira ku itariki imwe y'ukwezi kwa munane 2025 kwezi gushize.
For 4 children would be $40 per month.
Kuba aba bana bane bizajya biba amadolari 40 ku kwezi.
For 3 children would be $30 per month.
Ku bana batatu bibe amadolari 30 ku kwezi.
When there's only 2 children subject to the order, $20 per month.
Mu gihe baba ari abana babiri bagaragara mu kibazo bikaba amadolari 20 ku kwezi.
And when there's 1 child subject to the order,
mu gihe baba ari umwana umwe ugaragara mu kibazo,
it would be $10 per month.
Bikaba amadolari 10 ku kwezi.
Those new guidelines
aya ngaya niyo mabwiriza mashya
all call for $0 in base support.
Mu gihe ya yandi yibanze twigeze kuba tuvuga ahita aba 0 ku kwezi.
And just include the medical support only.
Noneho hagasigara hari aya ngaya yishyurwa kugira ngo afashe mu buvuzi bw'abana gusa.
And finally, the section 4D birth expenses were waived.
Ubwo bikaba bivuze ko rero ya yandi agomba kongerwaho yo kwishyura mu kurera abana y'inyongera yo agomba kuba avanyweho burundu.
Ms. Rummelt, anything further?
No, thank you, Your Honor.
Oya, nta kindi nabazaga niba hari icyo yongera havuga ko ntacyo.
Diane, anything further?
None Diane wowe hari icyo uza kongeraho?
Numva nta kindi kuko icyo nari ndi kwanga nuko nari kwanga ko bamushyira muri child support kandi mubona aba yatwaye abana nk'ubu ngubu ntabwo yakoze niwe wararanye abana bose aba yajyanye ku ishuri ni nawe uri ujye kubacyura bamugeraga kumushyira muri child support nkumva ni ibintu biri kungora aho kuba nta child support bamushyizemo it's okay.
No, I agree with this and I'm happy with the decision because I was expecting what you just decided. I did not want him to pay child support with everything he is doing, taking children to school, doing everything he is currently doing. I'm happy with the decision.
Thank you. Mr. Noel, anything you want to add?
None Noel, hari icyo wifuza kongeraho?
Jewe ntacyo kwere ndavuga ati murakoze cyane nanje burya ndi kwibaza uko ubuzima bwanje bugiye kugenda nkumva atari ariko icyo gisubizo avuze ubwa nyuma kiramfashije gitumye nduhuka arakoze cyane.
No, I have nothing to add and I have to thank you for the decision you have just made. I agree with it. I'm happy with it because I was concerned with what my life would be with paying child support, that huge amount. I'm really happy. Thank you so very much for that decision.
All right, Ms. Rummelt, I think we have a deal. You want to send that to me, please?
Yes, thank you, Your Honor.
Murakoze rero, kandi nawe arabashimiye.
Thanks, Ben.
You're welcome, sir.
and you can tell everybody to sign off.
kandi mushobora kwigendera turasoje byari ibyo ngibyo.
Thank you.
You are Anna Sleeman?
Yes.
Good morning.
Good morning.
And you are Jared Morse?
Yes, sir.
Morse, good morning.
Good morning, sir.
So I have read your motion, Ms. Sleeman, and you received a copy of that, Ms. Morse, or Mr. Morse?
I received it this past Sunday that I believe was 7 or 8 days, or at least 5 days past when it was sent.
Okay. Any reason for that? You've been having mail problems, that type of thing?
I broke up with my girlfriend about 30 days ago, and until I threatened to call the post office, all of a sudden mail was running on a Sunday.
Oh. Well, we have a problem. Okay. This case, Ms. Lehman, that you filed under 19-10392-DC no longer exists. It was dismissed. The case was dismissed on March 10 of 2020 due to what they call non-service.
Right.
They couldn't serve. Apparently, there was a problem with service, and the clerk 5 years ago dismissed that case. So I guess what I can tell you is that the only pending case that you have with Mr. Morse is a PPO case.
Yes.
That's the only case that I have you in our system with. So I can't grant any type of motion. And what you're going to have to do is you're going to have to file your own motion or your own complaint for custody support and parenting time because there isn't one for you.
When I went into the legal assistance at the courthouse, I tried to do that, and they told me since there was an open case in 2019 and it was closed, they said that they had to go off of that same case and reopen it as me, the moving party. So I went to them and I did all that. That's what they did for me.
No, that's not even correct. You need to file your own complaint. You need to start right from the very beginning. You need to file just like there was never a case existed. The Legal Assistance Center, they're very helpful, but they're not lawyers. This case was dismissed. It doesn't exist any longer. So you can't use this case. You have to start a new one. So, and they can help you start a new one. And if they have questions, you tell them that I said you have to start a new one. You can't use this case because it's been dismissed.
Okay, that's what I tried to question them with that because it didn't sound right. So I'll just go back in there and do that.
Or consult with an attorney. That might help even more. But because usually attorneys are not as expensive as you think, and some of them even offer free initial consultation, and maybe they can help things along for you. Okay.
Yep.
All right. Good luck to you two.
Your Honor, may I please say one thing?
Sure.
I understand that this case isn't active. I just want to say that me and her already have a written and notarized custody agreement.
Great.
And it's very detailed. It's 50-50. So she has put out a false claim, which my lawyer is sending evidence to the prosecutor right now that she premeditated all of this. Now she's put out a no contact order. My question is, how do I get my son without her showing up at the same time and getting me in a bad situation? I have a notarized agreement saying we have 50-50. How do I get my son without making matters worse until it can get figured out?
Well, that's a good question, but I can't answer that for you. I can't give you legal advice, Jared. Your attorney can, and you may want to consult with him or her about that. But there are a lot of people that have children together that also have personal protection orders, and they figure out ways to work that. So what I would do is ask your attorney to give you a hand with that. But right now, you might have an agreement, but there's no court order. And you need to have